the member for Bradfield.
Thank you, Mr Deputy Speaker. I'm pleased to rise to speak on the Corporations Amendment, Phoenixing and Other Measures Bill. Mr Deputy Speaker, the question before the House this evening is not whether phoenixing, which is, I might say, a particularly ugly word when it's used as a verb in this context. The question is not whether phoenixing is a deeply objectionable practice. Of course it is deeply objectionable when company directors and managers use the corporate structure to defraud creditors. There is no question in the mind of anybody in this place as to whether phoenixing is a highly undesirable kind of conduct which ought be prevented to the maximum extent possible. Madam Deputy Speaker, the question before the House this evening is a more specific and precise one, and the question is this: are the measures contained in this bill in fact effective to deal with the question of phoenixing? Are they in fact in any way linked to the conduct of phoenixing? Or are they instead yet another example of a technique which is all too common from this government, the technique of identifying a problem, offering what is claimed to be a solution, but on analysis is found to be deeply deficient and ineffective? And this technique is one which we see all too commonly, and I put it to the House, Madam Deputy Speaker, that we are seeing this technique being used yet again. I want to make 3 observations in relation to this bill in the time available to me. First, that phoenixing activity is of course highly objectionable and to be deplored. Secondly, that there is no evident linkage between the measures contained in this bill and phoenixing conduct. And thirdly, that what the measures in this bill do is give a degree of discretion and power, additional discretion and additional power to a regulatory agency, ASIC, powers which can be exercised without the need to obtain, for example, a court order, and in the Coalition's view, those powers and discretions are excessive. That would be our view in any case, but clearly the scope of these powers and discretions needs to be weighed up against the effect that these measures will have to deal with the evil of phoenixing. And when, on analysis, we see that there is very little reason to have confidence that these measures will have any effect, that adds weight to the serious concerns the Coalition has about the excess of discretion, additional discretion and additional power given to ASIC. So let me turn to the first point I want to make in the time available to me, which is that it is uncontentious that phoenixing conduct is to be deplored. Phoenixing, as that term is used, is understood to mean, in this context, the transfer by directors of the assets of a company which has substantial debts, to a new company of which typically they are also the directors. To take a specific example, you might have a company called Paul Fletcher Ventures Pty Limited, which is engaged in dubious conduct and has accumulated substantial debts. What that company might do, I'm merely raising a hypothetical possibility, Madam Deputy Speaker, I hasten to add. What that company, Paul Fletcher Ventures Pty Limited, might choose to do is to hide behind the corporate veil, move all of its assets to a new company, Paul Fletcher brackets Brave New Horizons close brackets Pty Limited, and carry on business under that new name. Now, creditors who have been dealing with the company under the old name will find that the company has no assets with which to pay the debts it owes the creditors. It is, on any view, fraudulent, deceptive behaviour to be deplored. It is deplorable in all circumstances, but one of the circumstances in which it is clearly absolutely deplorable is when the creditors who are defrauded are employees of the company who find themselves unable to recover entitlements which are owing to them, long service leave entitlements and the like. It must be clearly, for anybody in this circumstance, absolutely galling to find that they've been defrauded, and yet the same directors of that company are now carrying on business, often under the same brand name, but as it happens, using a different vehicle, a different company, and therefore able to take advantage of the different legal personality of the new company and fail to pay the debts owing to the old company. Madam Deputy Speaker, let's be clear. It is not contentious between all sides of this House that that is deplorable behaviour. But, Madam Deputy Speaker, the question before the House this evening is whether the measures that are put forward in this bill are effective to address that undoubted problem. And that brings me to the second point I want to make to the House this evening, which is that there is, on analysis, no evident linkage between the measures in the bill and the conduct phoenixing which we are all united in deploring. What are the measures contained in this bill? The key measure, Madam Deputy Speaker, is that ASIC, the corporate regulator, is given significant new discretionary powers to wind up a company. And there are several specific triggers which allow that power to be exercised. Those include if a company is 6 months late responding to a compliance notice and has not lodged other Corporations Act documents in the preceding 18 months, or if a company's review fee has not been paid within 12 months, or if a company has been re-registered in the preceding 6 months and ASIC has reason to believe it is in the public interest to place the company into liquidation. There are one or two other heads as well, but those are the major ones that I want to deal with. Now, Madam Deputy Speaker, the critical point in analysing the provisions in this bill is this. There is no linkage on the face of the words of the bill between these powers granted to ASIC and phoenixing conduct. Nowhere in the words in the bill, nowhere in the text of this proposed statute is there a requirement that ASIC must form a view that a company has engaged in phoenixing behaviour. Nowhere is there a requirement that ASIC must have a reasonable suspicion that a company has engaged in phoenixing behaviour. Indeed, nowhere in this bill, Madam Deputy Speaker, which purports to deal with the evils of phoenixing, is there even a definition of phoenixing. Nowhere in this bill is there a definition of phoenixing. This is an approach to drafting which on any view is novel, and when you consider that the word phoenixing appears in the title but virtually nowhere else on the review I've been able to conduct in the language of the bill, it makes any reasonable inquirer highly suspicious as to what is going on here. The language of this bill, the structure of this bill, the drafting of it, Madam Deputy Speaker, give every indication of a desire on the part of this government to be seen to be offering a solution to a serious problem without having actually come up with a practicable, effective, workable solution to a serious problem. And this is perhaps not surprising, because this government has tried on a number of occasions to get to grips with the problem of phoenixing and has been unsuccessful. Last year, for example, the government included a series of measures targeting some aspects of phoenix activity in the Tax Laws Amendment 2011 Measures No. 8 Bill 2011 and the Pay-as-you-go Withholding Non-Compliance Tax Bill 2011. After examining those bills, the House of Representatives Economics Committee made a unanimous and bipartisan recommendation that the government should not proceed with those provisions. It said as follows, quotes, "However, the committee notes concerns from the business community and its representatives that the bills potentially apply to the broad range of directors, whether engaged in Phoenix activity or not. The committee recommends that the government should investigate whether it is possible to tighten the provisions of the bills to better target Phoenix activity." Madam Deputy Speaker, the government subsequently withdrew those provisions from those particular bills and has yet to provide any indication as to how it will proceed with those. But I would put it to the House that the analysis conducted by the House of Representatives Economics Committee and the finding that those particular measures did not effectively target Phoenix activity are findings which apply with equal force, or would apply with equal force, to the measures contained in the bill presently before the House. What we have in substance is the granting of additional powers to ASIC to wind up a company on its own motion without having to persuade a court of the desirability of that. There is no linkage to phoenixing. There is no requirement to form a state of mind or a suspicion that phoenixing is occurring. There is indeed not even a definition of phoenixing, and it is, I think, a heroic claim to describe this bill as in fact dealing with phoenixing at all. Let me turn to the third point which I wish to make in the brief time available to me. As I've argued, the provisions of this bill grant ASIC a very wide set of additional powers and discretions which can be exercised without seeking court approval. Let's consider, for example, the power to wind up a company if its review fee has not been paid within 12 months. ASIC might choose to use that for a whole range of reasons which have nothing whatsoever to do with phoenixing, including debt collection. Madam Deputy Speaker, I regularly receive complaints from constituents involved in business activities that ASIC's annual review fees are very steep, and they seem quite disproportionate to the value of the service actually received by the businesses which are compelled to pay these fees. It's very easy to imagine how a statutory agency like ASIC might fall prey to the temptation of using this wide new power to engage in debt collection activity to follow up fees which have not been paid. And again, I make the point, there is nothing in the grant of this power which confines it or restricts it or links it to phoenixing activity, notwithstanding the claim that this bill is about phoenixing activity. Madam Deputy Speaker, statutory agencies like ASIC play an important role, in this case in the supervision of corporate activity. But that does not mean that the Parliament, representing the people of Australia, ought to freely agree to hand them more powers and discretions without careful scrutiny and a careful weighing up of the benefit to be obtained against the possible reductions in the rights and liberties of the companies and the employees and management and directors of those companies with which ASIC is dealing. In my view, Madam Deputy Speaker, if you are going to give ASIC additional powers and discretions, you need to make the case as to how doing so is going to better allow ASIC to deal with the problem of phoenixing and produce better outcomes and a reduction of phoenixing activity. There is no persuasive case made in the explanatory memorandum, and it's very hard to see how there could be such a case made when you have a set of provisions which are drafted with great generality and make no reference to phoenixing whatsoever. Madam Deputy Speaker, I conclude as I began. There is no question that phoenixing is highly undesirable conduct. The Coalition stands ready to support effective, practical, workable measures. The measures in this bill are not effective, practicable and workable. They simply give extra discretions to the regulator, and the test as to why that should be done has not been met.
Expired.